You hear me okay?
Hello.
You hear me?
Yes, sir.
Oh, good. How about this? Does it sound loud and clear?
It does.
Okay, good. Yeah, you're coming through gangbusters. So, it's going to be unnatural, meaning, I mean, we're going to wear clothes, but we're just going to take it as it goes. Um, I'm a little under the weather. I just got up out of bed, to be honest with you. I,
Good job of
li-
making your bed.
I just got out. I'm just so sick. But I
Really?
wanted to be available for this. I'm a lot of medication. I actually had to call into a court and go, I can't make it. I never done that before in 30 years, you know? So that's how sick I was. That's just not me. I'm
Huh.
trying to figure out how to write to people to tell them, see, question and answer, no open questions, chat. Ah, here we go.
Do you like that look, the lighting it behind me with the unblurred?
I really do. I like the blue. I like the cat tower,
Okay.
but no cat.
No cat. Nah. He'd make too much. It takes some hours to settle down and
Oh,
show up.
really? How old is he?
7 or 8. Once he's settled down, he's all right though.
How many cats do you have?
3.
Whoa. How's your wife like that? Well, they're her cats.
Ex-wife, she doesn't care.
Oh, okay.
She likes him. She likes him better than she likes me.
Yeah. You were married for a while.
Yeah, I was. But I've been divorced for a while too, so that's been good.
I know the feeling, man. I
Um, you
I
see
did it.
here, I'm looking up because I have the camera is down here,
Okay, you're looking
and
great.
I'm looking at you on this screen over here.
Okay.
Is that all
Yeah,
right?
I make the same mistake, so I'm gonna try and look at, I
This
mean,
camera.
yeah, I'll try.
I could put it down, I suppose. Right? I mean, if I put you down here, then I'm looking down more straight on that way. So I sent you the talking points and
Looking
stuff.
right at him. You just gotta see something else. Almost there. Oh, come on. There it is. Someone already sent me questions to ask you. Time, all right. I'm trying not to perspire too much. Um,
Are you in Florida?
huh?
Are you in Florida?
Yeah, but that's not. It's cold in here, but I'm killing this virus in me. Every time I fly, I just got back from Michigan. I get sick. That's the only time I get sick. Okay, that's an easy one. I don't have to ask you that. So, I'm not gonna ask you that. How long do you have to? All right, so let's see. Participants, 3 already. Okay. Scott Mancinelli, is that correct?
Yeah.
Go. So there's just me and you and Cindy so far. Well, it's not 2 o'clock. Now it says 4 participants.
So they have to log in, they have to participate. They can't just watch.
They can do
Anonymous.
whatever, for lack of it, they can do whatever they want, allowed to talk. Let's see. Greg is now allowed to talk. Hello, Greg. Greg's on mute, but there we go.
Hey, how's it going?
Good. We're going to start at 2. We're just chewing the fat right now, getting ready,
Hi,
figuring this
Greg.
stuff out.
Hello, nice to meet you.
Yeah, you too.
You want the first question, Greg?
Uh, I think Paul's going to handle the questions, at least for now.
All right, so I'm going to talk up Scott here before I do anything. and I am trying to let people in now. Here they come. Hmm. $157. How's the weather up there, Scott?
Hot. Hot and stormy.
My kid has been sending me nighttime electrical storms from his window. It's quite a. I got out of there just in time. I left Sunday night, and then Monday, I guess that's when the stuff hit the fan.
Yeah. Yeah, it's been intermittently hot and stormy and thunderstorms, etc.
Can you see the people joining now?
I see a few, yes.
Okay, good.
It looks like we got an attorney, Andrew Wagoner, perhaps.
Hi. How's it going, everybody? How are
Okay,
you?
he's dressed so nicely.
So work
Are
from
you-
home, it gets to you eventually, right?
I love it. If it gets to me, I just walk outside.
Hello.
Hello.
Hi, it's
Hello.
Nicole.
How's it going?
How are you?
We're going to okay, ask to unmute. Paul, are you there? I hope I didn't press the wrong button there.
Hey, Brian, how are you?
Hey, here you go. This guy's a good guy. He's on this Scott, this guy, watch out for this guy. He probably knows your job as well as his own. He settles cases all day long. It's his job.
Who's that? Which one?
Paul.
Paul? Okay.
I
Hi,
don't
Scott.
like
How are
saying
you?
your last
Hi,
name. How do
Paul.
I pronounce that, Paul?
It's just Kill. Yeah, I know. It's a funny last name.
Kill. Okay. Just making sure that I'm letting everybody in. Actually work. Okay. All right, Scott. Shoot. We'll wait till it's 2. I don't want to. Hey, Paul,
Yeah, Brian.
can you see the question and answer that I have format of your questions?
Um, where would it be? In the chat?
Yeah.
I don't see anything in the chat, no.
To hosts and panelists.
Yeah, I don't see anything typed in. I'm gonna type something in. Can you see this? I just typed something into the chat.
I can see that.
Okay, so I don't see anything above that.
Shoot, how about below?
Nothing, no.
It says format your questions.
Does anybody else see anything? Andrew, Greg, do you guys see anything in the chat?
I'm not seeing anything.
Oh,
No.
Well, it isn't important what I say. It's important what you guys say, seriously. So I don't know why that is the case, but I'm going to start now. It's 2:00. Scott has bravely given me 2 hours of his time. For matter of introduction, Scott Mancinelli is a guy I come across or up against maybe once or twice a year, maybe once or twice every couple of years. And he's one of the few attorneys on that side of the fence or that side of the V that I respect highly. And he doesn't just slap stuff together. Like a lot of my genius, quote unquote, is just using the other side's documents against them. If you watch my videos, that's all you hear me say, but it's true. And Scott presents me with a real task. I actually have to do a lot more work because he puts more work into his. I think he respects his clients. That's what I think it is. A lot of the work against debt collectors, it's so shoddy, the complaints. Now, the other side of that is this filing thousands of those complaints and somebody signing off on them or creating them for them in another state. But you have a certain modicum or a minimum standard of care. Scott far exceeds that in his work and exceeds most people that I deal with. So it's a real joy to have him here, and it's going to be a wealth of information for you all, whatever your questions are. I have a couple of jobs to do as I'm talking. One is to let people in and just to keep an eye on things on top of asking Scott. And I'm trying, believe it or not, I'm going to be doing a lot more listening than talking. But Scott, how you doing today?
I'm great. I think
Uh, you tell us a little something about yourself from the beginning to where you're at now, briefly.
oh, okay. So, I from the beginning, I went to Hope College in Holland, Michigan, which is my hometown. I've got a major in political science and history. Um, I went to University of Oregon Law School in the 90s. And while I was there and in the summers, I worked in salmon canneries in Alaska, and I worked my way through college in furniture factories in Holland and cooking and things like that. So I've got a lot of, working class background, before I became a lawyer. Practiced law in California for 6 years, often doing consumer bankruptcy work and working for, uh, you know, eh, people who are discriminated against, wrongful termination, discrimination, consumer bankruptcy, but also had some business collection clients back then. And that's where the collection work first started. I had actually the phone books for Southern California was one of my main clients. So we were suing on businesses who didn't pay for their phone book ads. Moved back to Michigan in 2000 and continued to do consumer bankruptcy and general practice. And then I moved into a firm where we did a lot of commercial collections and commercial loan workout, trying to keep factories open, trying to keep farms operational, but paying off their loans. And sometimes we would have to liquidate and sell off assets, but sometimes we got them fixed, did forbearance agreements and did deals. And then that eventually transitioned into, we did that so well that the bank started asking us, hey, can you handle all these smaller cases for us? And so that's what the transition was to the consumer collection. And the debtor bankruptcy kind of faded out, and I did a lot more creditor work in bankruptcy.
When someone, you go to a cocktail party and someone says, "Hey, what do you do?" What is it you say to them?
It depends on who they are, but sue your ass and take your money.
All right.
But it depends, I'll tell them I solve problems. Ultimately, is that we figure out ways to do deals, and we get people together and work out a deal. And if they're not willing to deal, then we will pursue the litigation and collect the money. But if I'm in a group of, creditors, then that joke does kind of take flight.
But so it sounds like you will pursue, but before you pursue the debtor, that area between your filing a lawsuit and your pursuit, is there room there for someone like a debtor to settle this case, convince you they don't owe it? I mean, what is the mechanism or parameters there? How does one approach a debt collector attorney, and how does one win you over? What's the techniques or rules that they should follow?
Well, there is a window of opportunity to get these things done without litigation. So the initial stage is, let's assume we're in the opening stages of a matter, and you've received a letter from me or some other debt collection attorney. If you don't ignore the letter and are willing to communicate and reach out, don't ignore the letter, don't circular file it, but call or respond and start a conversation. And that will always be less expensive for you in the long run.
If someone receives your letter and sends you a validation request, what is you or your office's thoughts on that and response to that? As vis-a-vis wanting to work with the data, does that put you off? What is that, your thoughts on that?
It depends on what they say. I mean, if hopefully they're giving me some information to go on. I just get a dispute that says nothing. Sometimes I'll get a dispute that says, identity theft. We will look at it. Go through all the media again and all the contract and all the documentation. We'll ask for additional documentation from the client and try to sort out what it is, respond to whatever their issue is. And we will always send them, a specific letter that is not a form letter, but it specifically addresses all of their issues with supporting documentation.
How much time do you spend weekly or monthly keeping up with all audits, CPFB, government regulation intervention? How much of your law practice is dealing with that type of situation?
2 to 4 hours a week, because, and I tried to be quite, pay attention to compliance, right? So, we don't have too many issues, frankly. I've learned to make quality letters and to deal with people in such a way that they don't want to pursue. I've never had a CFPB complaint ever.
How long have you been doing this?
Collections, 25 years out of 30 years of practice.
Wow.
So I've had a few people complain about various issues, but typically they were just valid debts that they just didn't want to pay.
All right. So you get a case comes in from your client. What's the approach you take from beginning to end?
Okay, so I've got a debt collection client who wants to pursue, review the media, make sure they've got all the contracts and documentation, that they have the bills of sale if it's someone who's taken assignment of the debt. I check out my own client's background to make sure they're not being sued for anything, to make sure they don't have any issues. I'll decline clients if I feel like they're a risk to me or they have a bad history. And then I look into who they want to sue. And sometimes I'll find that, it appears that some of these people are not collectible, and it's just not a good use of time to pursue them. And then we work up letters to the debtor, send out the letters, make sure we have good addresses for everybody, make sure we know that they're still in Michigan and still alive and not in the military and not bankrupt. We run all these background checks. So we eliminate all these people that should not be sued from the get-go. And then if they're not responding to a couple of letters, maybe I will send an email if they've already signed something allowing for emails. But after that, they're going to get a lawsuit.
You said something about in the military. Touch upon that briefly.
You can sue people that are in the military, but they kind of get they have some protections. And if they're, if they're placed overseas, or if they're on, active duties out of the country, it makes it more difficult. And basically, it's just not worthwhile to sue someone in the military.
Okay, so is there specific laws governing the military lawsuit?
Yeah, there's the Soldiers and Sailors Relief Act, and there's other laws, and it comes up so infrequently that when I do have someone that's in the military, I will essentially just put that case on hold until they're out of the military.
So what do? You just put it on the shelf?
I just put it, calendar it for a follow-up in a year, because the act that gives them some leeway from being sued or being collected upon also extends the statute of limitations for my clients.
What states are you a member of the bar of?
California and Michigan. California was early on, and Michigan from 2000 to the present.
Do you still practice in California?
I have not recently, but in the past 5 years I have. I used to get involved in class action cases in California from here.
Your clients are being sued or you're suing?
I would object and interrupt the whole class action and represent objectors in class actions.
And explain briefly what you mean by that.
Well, it's kind of phased away, but you could, if I would have clients who are members of the class, and they're like, what can we do here? And I said, well, are you happy with the settlement? And she goes, no, I don't think it's very, very generous. And so I'd represent them, and I'd file an objection and appear and throw a wrench in the works and try to get a better deal for the objector.
So you're on my side of the V. You're a good guy.
Sort of.
All right.
I'm a good guy in general. I do, I represent consumers too.
In what way?
Well, our practice is not just entirely debt collection. It's also business representation. I could have two businesses locally that are fighting over the delivery of a piece of machinery or an order of goods. We do divorce work. We do probate stuff. We kind of specialize in probate fights where, for example, son is the beneficiary of a trust and uncle is the trustee and dad is dead and uncle won't pay the son his money. So it's sort of like a probate collection or a probate bad faith case. We have many of those. So, if you're the beneficiary of a trust and you're not getting your money, we can help you.
All right. So one thing you didn't touch upon when I asked you how you approach a case, and this is important. Our viewers may want to hear this. What is your policy? I've noticed in my work, each firm or collector has different types of policy behind reporting a debt to a credit or a credit bureau. Is there a certain time, way, or do you avoid it altogether?
I don't report and I don't take clients who report.
Why is that?
Because once you start reporting, you have to continue to report in kind of indefinitely, and it's a hassle. So I don't report bad, I don't report good, we don't report at all. And that's one of the criteria I tell my clients is like, I don't recommend it, and I don't find it to be a useful collection tool. So that's for very big Discover and Visa and Citibank and things like that. But I don't find it useful, and it opens up a whole realm of administrative compliance that I don't want to deal with. And the costs outweigh the benefits of credit reporting.
Okay, so I'm a debtor. You've got a debt of mine for $1,600. Let's say it's a Discover card, and you just sued me. What should I do in the next 21 days?
One thing you should not do is nothing. You should read the thing through thoroughly and then be willing to communicate. Contact us and don't call us mad. Take a minute, think about it, and don't call if you're angry or upset. Write out what you want to talk about, maybe make some talking points, and then call and explain what your situation is. Communication is number one. If you're reaching out to us before the lawsuit or immediately after the lawsuit, it's going to save you money. It's going to be ultimately cheaper for you in the long run. And
Why?
Because attorney fees don't get added. We might do a deal without interest. There won't be extra costs. So all these things that cost me money or cost my client money won't be incurred. That's which is why you should call in response to the letter, because filing fees and service fees all get thrown into these judgments. So if you're delaying until after you get sued, you just added more amount to the debt.
All right. So a question I have about that is, let's say it's 5 years ago. Tell me what your feelings were about debt settlement companies, and now today, what your feelings are, whether good or bad or plus or minus, about debt settlement companies.
Personally, I think they just delay things, and the deals that debt collection companies are doing, I could do without them if they just contacted me. Now, I don't know what the motivation is on the part of the consumer. Maybe they're trying to settle a wide array of debts. I don't know. And maybe that's better for them. But if it's just my one case, whatever deal you're trying to get the company to do for you, you could do with me. But maybe it's too anxiety inducing or something. And maybe some people just need to have that representative. I don't know. They usually hire incredibly bad attorneys. And there's never been, I almost always get summary disposition on a consumer who's hired a settlement company that then hires an attorney. Terrible. So you're getting mediocre legal representation through the debt consolidation or the debt settlement company. And their settlement numbers are often unrealistic. So they're like wanting to settle for 30% or 40%. I'm like, no, I know this person's background. It's not reasonable. We can do almost any payment plan that you want, but I'm not going to discount this debt by 40 or 50%.
So if I'm a
Absent-
debt settlement company, how do I approach you? What's the best way where I'm going to win favor with you and you're going to give me the best deal possible? And then B, what is your flexibility about making a deal? Like what you've been talking about is stuff on the ground. You've not talked about your client's parameters for you settling. You've been talking about yourself and how you settle and the one-on-one and the communication. So what part does your client play in a settlement?
Depending on the client, I have a range of settlement authority. That could be quite large or it could be quite narrow, depending on the client and the amount of the debt. And so within that range, I can largely do whatever I want. I also, as long as they're paying the full amount, I can do almost any payment plan that seems reasonable to me based upon the information that I have.
And that's the only time you can do a good payment plan, when they pay the full amount?
No. If there's other reasons to discount, again, it goes back to the next. So, communication next is honesty, right? So don't make up bullshit stories. Tell me the truth. If you lie to me, I'm just going to figure it out. I've just been around too long to hear a BS story, right? But, if you really are disabled, then tell me that and send me their disability statement. If you have 5 kids and you're a single mom, send me a page from your tax return listing all these kids as dependents. If you have a special needs child, then send me something on that, a diagnosis, or you've got, cancer, whatever. Just back it up. Be willing to back it up with some documentation, because then I can go to my client and said, hey, this person's told me they've got this issue and they've backed it up with supporting documentation. Can I do this reduced hardship settlement deal? And they will invariably say yes.
Briefly go over, I guess it would be federal, the exceptions. For example, if you have a garnishment against a person that is only on Social Security, you mentioned disability or receiving a pension. What are the rules behind whether you can lien or garnish those accounts? I always tell clients, and you can tell me if I'm wrong, it's good. Create a fund, a bank account that says Social Security, and do not commingle with anything else. And you're largely going to be garnishment proof. I may be wrong about that. What are your thoughts on all that? What are the rules?
I would generally agree with that. That Social Security monies and disability monies are not garnishable. If and the banks will look back a certain amount of time if they get a garnishment to see if there are exempt funds in there. Okay. But if you have such an account and you never spend the money and it just builds and builds and builds, then the banks are only going to say that this amount of money, the 90-day look back or whatever the look back period is exempt, and they're going to allow the rest of the garnishment to go through.
Why?
Because there's only a certain amount that is exempt unless you, the debtor or the consumer, files an objection. That's my recollection.
If
But
it's all
frankly,
Social Security or pension or protected money, what difference does it make how large is in that account?
well, that nobody knows. The banks are only looking back so far, right?
Mhm.
So they're only looking back so far to see where that money came from. The creditor has no idea. I have no idea. So if you have $10,000 that's built up over years in an account that's also security, you should file an exemption, an objection to the garnishment and say it's exempt, and provide the statement showing that it's exempt. Otherwise, they're going to assume that money that was beyond the look back period. There's a mathematical formula for it. I don't remember it off the top of my head, but there's a formula for how to calculate that out.
And that's federal?
Yes.
All right.
Now, pension money
Go ahead.
is not exempt. So if you have an account that has nothing but pension money in it, it can be garnished. I can't garnish the monthly pension, but once it's in the bank account, it is garnishable.
Why is that?
Nobody has carved out an exemption for that. So no state or federal, it's just money that's available. It's not, I can't I can't do a periodic garnishment to Fidelity that's paying out a GM pension. But once that money is in the bank account, there is case law saying it's not exempt.
Now, you and I came across each other, I believe it was on a foreclosure account. And what's happening today is, I don't know if you're aware of this, there's a lot of zombie mortgages showing up. And there are some that say, hey, they can't touch me. It's after 15 years or 10 years or whatever the statute of limitations is in Michigan. Let me present you a scenario. Gentleman loses his home. They take the home. He has a second note of 14 years ago, and they say 2025, it's supposed to come due, even though the house is gone. You owe us the 125,000, for example, you took out. Does he have any protections or ways to stop being?
And the default is 14 years ago.
Yes.
That would be a beyond all statute of limitations.
So it's not 15 years, it's 10.
15. So let's say he's still in the house.
Okay.
There's a 15-year statute of limitation on the mortgage foreclosure. So he could be in default for 12 years. He's still in the house. And for 12 years, they've got no payments. The 6-year statute on the note is gone. The 10-year statute to sue on a covenant in the mortgage is gone, but the 15-year statute to begin foreclosure on the mortgage is still available.
Are you collecting a zombie? Well, let's call it second note debt. Is that part of your practice?
I finished it all up. There's nothing left as far as I'm aware.
Oh, okay. I've been reading a lot about the zombie mortgage debt is showing up again.
Oh,
Hey, there you go. All right. If anybody
my
has
day.
any questions, I am scanning through. I don't mean to dominate.
I don't know that we finished, how to handle if you get sued.
All right, keep going. Sorry.
We had honesty, if again, you tell me your story and it's truthful, I'll work with you. Take accountability and responsibility. If it's your debt, don't try to blame it on the creditor or blame it on your son that you co-signed the loan for to get his car. Just accept the responsibility. And then, we can I appreciate that, I will work with you. I will possibly discount the debt. I will ask the client to reduce interest or freeze interest. By the way, another reason to do a deal before you get sued, because almost all my clients will allow me to freeze interest pre-suit.
What does that mean?
It means that they will not charge you interest on your settlement or your settlement payments. But once I've got a judgment and there's a judgment interest rate built into it, they are highly unlikely to give up on the interest.
What about your debt buyer clients?
That's absolutely, they agree. They let me do that.
Because most of the settlements, if there's so much, even I can't get it eliminated, and there's a payment plan on what's left, they will always give me no interest payments. You're saying you don't have the authority with your clients to do that?
I have less authority post-judgment than I do pre-judgment or pre-suit.
Oh, yeah. Well,
but yes, I can get authority to reduce or cut interest. If it's supported by documentation.
So be honest, be accountable, communicate always. If you get a letter, communicate.
Be creative. Be willing to put up some collateral or make a big down payment to buy yourself a lower interest rate or get a big discount. All these clients want to get more money up front. So if you got a $30,000 debt and you want to go on payments, but you can put 10,000 down, you'll probably get a discount and you get a very reasonable payment and or interest rate.
like a hybrid approach.
Correct. I often build in early incentive payment, rewards. So if the settlement is 50, but if you can pay 35 within 6 months, you're done.
So talk to me briefly about creating a consent order. What is it and what goes into creating it? And what are the protections for the debtor and the protections for you?
So we've had some conversations. We've gotten enough information to figure out what they can afford and what's reasonable. I'll let I'll often say, what is it you can afford to pay? If it's a small debt under 5,000, I'll ask them, what do you want to do? And they'll say, I want to pay 200. I want to pay 150. Okay, fine. We'll do that. What day you want to pay it on? They pick a day. So I will then prepare a consent judgment for the balance with the payment that they want. And I will say to them, can you pay more? If you can pay more per month, we will reduce your interest rate, or we will maybe give you a small discount. If you can't, that's fine. We'll do this. I'll prepare a consent judgment that's built in with a payment plan and the date that it's owing. I'll also prepare a post-judgment forbearance agreement that allows them to, gives them 5 or 6 different options about how to pay, mail a check, pay online, pay by phone. We take the payment from their bank account, all kinds of different options. And we will also give them 7 to 10 days notice if they miss a payment via email, so they can cure if there's a problem. Was there a question?
All right. I think do we have our first question? Does someone have a question?
Back to your state license. Where you live?
Hello?
You don't think we should get this lawyer for this?
Miss Kidd, Jillian?
Oh, hi.
Hi.
How are you?
Great.
didn't even
What's
know
going on with
If
you?
hear me. So I know that you practice in Michigan, but I'm from New Jersey. Can you hear me?
I
Yes.
can.
Loud and clear. Very good.
Okay. And the question is, if the debt collection company is suing me, they have to have a license in the state that they're suing me in. Is that correct or not correct?
Depends on the state. So a debt collection company is not necessarily suing you. Whoever owns the debt is suing you.
Right. I worded it wrong.
So
that
the
collector that is suing me, it's not, they have to have that license in order to make the complaint.
let me answer it from a Michigan legal perspective. So in Michigan, an owner of a debt does not need to be licensed to sue.
Okay.
If the attorney is licensed by the state bar, and if you're getting calls or letters from a collection agency, they need to be licensed. But the owner of the debt does not. I don't know what the requirement is for New Jersey.
And Jillian, a lot of states have what are called local debt collector statutes. In some cases, they're actually better than the Fair Debt Federal Collection Practices Act. For example, Florida, if you're not licensed, you go to jail. No, you don't go to jail, but you have to pay to the debtor and you're in a lot of trouble. So that's a state where you have to be licensed. Whereas, as Scott was saying, Michigan, not so much. Debt collectors, when they go into a state, and correct me if I'm wrong, Scott, they look at how regulated the area is. Like, for example, you don't really have to volunteer to be licensed in Michigan. And I used to gig people that did do that. They thought they had to be licensed. And then there's other states. Maryland is one that a lot of debt collectors don't like to go in there. And the rules are always changing. California is heavily regulated. So debt collectors think twice about going into a state. Are there, as you suggest, some that kind of go around the fringes and go where they shouldn't before getting licensed? Most likely. What I would suggest you do is, and this is what I used to do before licensing wasn't an issue, I'd go onto the corporate website of Michigan and look who's licensed, who isn't.
Right. And I just wanted to be sure. And the people that are suing me, they are not licensed here.
So you can Google in New Jersey, does a debt collector have to be licensed to collect or operate. And again, as they're saying in Florida, that's strictly for boating. You have to be licensed.
Okay,
Maybe
so
New Jersey is the same way because they are a, if you will, and I don't get political, but they are sort of to the left of things. It's a very democratic state, and that usually means heavy regulation. Does that make sense?
yes. So I just want to be clear. The lawyer that they have is from New Jersey as well, but the company themselves have to have a license in order to get the lawyer and have the lawyer sue me.
And that's what the law is in New Jersey?
Yes,
Have they sued you?
yes,
Have you answered the lawsuit?
yes.
Have you cited in your defense or affirmative defenses that the creditor, in this case, if I hear your fact scenario, is unlicensed?
I did not, because I just found this out.
All right. How long
So
ago
I'm
did you file your
learning
answer?
as I'm going, you are such a blessing to me, believe it or not. So I'm following everything that you're saying, and that's where I started out. So I did I answered the complaint, I did my affidavit, but I've done this like way back in February. So a lot of new things are coming up. So I'm just trying to kind of, I guess, if I need to amend it, I could, but
What is a blessing in New Jersey? They've sort of slowed down there as far as like in Michigan, you'll have a pretrial within a month. In New Jersey, it's real slow down. Have you had your first pretrial yet?
yes. So I actually got one canceled out. So one of the loans where it was he let that one go.
Good.
So
So you want to do a motion then to amend your answer. And
Okay.
how you would do that is you'd write up what your answer you want it to look like, attach that as exhibit 1, tell the court, I've just discovered evidence that this, and make a big deal about that. That is your reason, but make a big deal. Like they're coming into New Jersey and da 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 da, you know? So not only, even if you, I'm a big believer, even if you lose a motion, get it in the judge's head, your position. Never give up on a chance to state your case. So that you always win, even in a loss in that situation. But I think you'll win to amend. And what I really think will happen is if you're right on the law, that case will get settled. So to get to Scott's point about communicating, I would contact the attorney and say, look, I'm about to file this motion. Would you agree? I know you think it's not going to work, but hear me out. Would you agree to let me stipulate to amend my answer? And she's going to, so he's going to say, he or she's going to go, Miss Kidd, what is the basis of this? You go, well, I've discovered your client isn't XYZ, and here's why. If you're right, you may settle that case on that phone call.
Okay. So, and I was kind of nervous about that. And the only reason why is because I didn't want to give them enough time in order for them to get that, get the license.
Well, they can't retroactively. It's like if they break into your house, if they go, clean up the window they broke, it doesn't mean they didn't break into your house. You've got them in that regard. Scott may see it differently. What do you think, Scott?
I think they could just dismiss and refile it and fix it.
See, that's what I don't.
If it's really your debt, I mean, it's correctable. So if it's really your debt, then you should probably reach out and try to do a deal, knowing you've got this leverage, or maybe you have a motion.
Right. And that's Scott's point about communication. You've got leverage, and act very serious about wanting to do this. Never threaten anything you aren't going to do. And don't let them say, okay, we'll get back to you, Miss Kidd. You go, by the 7th of May, I'm going to file this. I'm reaching out to you because I believe communication is a good thing, and blah, 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 blah. And okay, so Scott and I are going to butt heads in a friendly way here. If you don't, whether you owe it or not is irrelevant. Sorry, Scott. If they are suing you, they've created a higher standard of care, meaning they now have to show a burden of proof. So there's 2 forms of collection. There's the one before the lawsuit and the one after, and of course, post-judgment. But the standard is much lower if it's pre-lawsuit. Post-lawsuit, they have a burden of proof. Even if you owe it, they've got to show the court they have standing. So Scott and I are going to see that differently. I'm going to say they have no business suing you. He's right about if you owe it, that is the standing. But who, by the way, if you don't mind, who is the plaintiff?
The plaintiff is Absolute Resolution.
Oh, you don't know that. Don't even try.
I wish
that-
you would do a video on them
I
specifically.
did. I
like
did
all
too.
the way through.
It's specific. Take a look on my membership site. Maybe it's YouTube.
Mhm.
All the paperwork. I've got at least, I think, 1 or 2 on specifically. I just did an absolute. I'm always doing videos on cases that I'm doing because I prefer to give you real cases. When I was in law
Right.
school, I wanted attorney professors. I didn't want professors that look in books all day.
Well,
So that's what I
hopefully-
want. That's
on
what I
crit-
want you to have for me, someone that's actually litigating. An
Gotcha.
absolute, that's a joke. There is no way. Do not do your best, but you don't know that.
Great. Can you do one? Just saying, because I'm going through another one too. The company is Credit Corp.
That is my next one. I thank you
great.
for reminding me because
Great.
I used to do a lot of credit card back in the day, and then they just dropped. But I keep hearing more and more. So I'm going to do one for you. It's just that I haven't done one myself. As I said before, I have done plenty, but I haven't done like in the last 2 years.
Okay.
Let me scout around.
I
Any
can give you something to do if you like. I can send you the paper.
any video on MCM, Absolute, Crown Assets, UHG. Just go on my membership site. There's like 10 frequent flyers there. Any one of those is what you can use for Absolute,
Mhm.
or in your case, Credit Corps. They don't have the paperwork, and they're a large enough outfit where they file these lawsuits constantly where they don't take great care, as you've seen in my use their documents against them. All right, Ms. Kidd, you're the greatest. We're
Thank you.
moving on. Does anybody else have a question?
Yeah, I have a question. Hi, Scott. Thanks for taking
Hi.
the time, and thanks, Brian, for inviting us. So I have a specific question on like if a debt gets dismissed, like a case gets dismissed, either due to lack of evidence or lack of, but for whatever reason, it's dismissed without prejudice. What are the factors that go into the likelihood of a new suit being filed as opposed to just the debt going back to whatever creditor it is?
That's a great question. I asked that myself. Great question.
We don't know why it's getting dismissed, so that's a big, I mean, it could be that if the client has the media and has the supporting documentation and you are in that jurisdiction, or they can locate you, then and it's a significant debt, it's not outside the statute of limitations, it's probably going to get refiled. I have cases that are just dismissed for non-service because I just can't find them, or they're hiding, and they get refiled typically.
Can you give us a fact scenario, caller, talker?
Paul?
Okay, for instance,
Paul.
all right, so if I recall one, there was a case, it was a Bank of America case with Javich, and it got dismissed, but we don't know why. We just know that that they dismissed it voluntarily. And then we're expecting, but then when we reached out to them to see if they wanted to settle, they were kind of stonewalling us. So it kind of made me wonder, is this debt, do they know that this debt is going to go back to Bank of America, or do they know that they're refiling a new lawsuit? I didn't know. I still don't know. It's still ongoing, but that I'm a little in the dark about it. So I was just wondering maybe if you could shed some light on something like that.
Yeah, what can
It could-
Paul do?
Well, if they're not communicating with him, then not much. But you might go get the court file and find out what they sued on before, get a copy of the original complaint and the other things, and if the attorney's not willing to talk to you, you could reach out to the creditor. That would probably light a fire under the attorney because the client's going to call them. Could be that the client decided didn't want to sue, or it could be that they sold it and now they're pulling it back, because If it's Bank of America, that means it's the original creditor. So it could be that Bank of America sold it all off and said, hey, cancel this thing. Or there's some other glitch came up or issue came up, could be. So that happens sometimes with people who have very, generic names, John Anderson or something like that. They sued the wrong John Anderson, or they mixed up the media. Who knows? We're kind of speculating.
All right. Thank you so much.
Yeah.
Next question. Got great resource here. All right, I got a question.
All right.
Let's say you're going to court and it's a judge you just don't mix with. You, no matter what you do, it's almost like he's purposely against you. Do you ever have that feeling?
Yes.
What do you do about that?
Send my partner.
Okay. But your partner's up north fishing and you have to go. What do you do with a rascal of a judge? And I ask that, I have a video on what I do, but you tell me what from your side.
I try to avoid going to the judge and try to cut a deal. So I'll immediately, like if it's a Zoom hearing, I'll say, hey, Your Honor, can you put us in a breakout room? I think I could work something out.
So you're saying if the judge sucks, I mean, causes you issues, that's reason enough for you to want to settle that case?
Yes.
Wow.
Now, there are judges where I have figured out what they want, and I will show up with all the things that they like ahead of time. Judge Maribel in Flint, for example.
You are the only one.
I know exactly what he wants. So what
is it?
Well, he has issues with
Explain who Judge Mirabel is in a nice way. I don't know if you can.
Judge Maribel is a judge in Flint, Michigan, and he's very particular on certain things, and he's somewhat mercurial, and he doesn't care how much time he'll use up on something, and he'll drag out hearings interminably, and he forces hearings on matters that really don't need a hearing at all, like renewing.
But I sense that he's as interesting as he is to watch. And that, by the way, you can Google him and find some great videos. And I've actually watched the clerk just stand up and just scream at him. I mean, that's how tense that courtroom is, really.
The clerk?
Yeah. she runs that place and she just screams at him. But I sense that he's pro defendant, me, the debtor, more so than he is you. Am I wrong?
That's fair. But if it's a local creditor, like a local landlord or some, one local person against another, he's pretty neutral. I've observed that. But I've observed many other attorneys going in, particularly appearance attorneys, and they just don't have the information, right? So I go in there and I've got all the things that he wants. Like he wants to know if you're going to renew a judgment, what efforts have been done to collect, who owns the debt now, is the guy in the military, has the plaintiff ever been sued for, class action? And I'll make an affidavit and I'll cover and I'll attach exhibits for everything he wants. And I give him definitive answers then, because he goes through his list. And most of the time the attorneys get in trouble because they say, I don't know. But I'll say, no, 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 yes, no, no, no. And here's my affidavit. Oh, you're handling this pretty good, counsel. I like the way you handle this. This is exactly how he said it.
Yeah, but he gets involved in cases and facts that have nothing to do with the case. He'll just bring up some. So for a minute, I'm like, is this guy like a genius and he's going somewhere? Then you realize there's nothing there. He goes off on wild tangents for sure. Yeah. And when you have let's say you have a 2:00 hearing, bring a lunch and bring other work to do, because it's going to be a while.
It is. Yeah.
That's how you handle a judge that you have difficulty with. You try to figure out what they want. Of course, be respectful. Think outside the box. How you've done that with that judge, good for you.
So I got on his good side early.
Yeah. Do we have any more questions?
Right, I have one.
Okay.
Go ahead.
Paul?
Go ahead.
Oh, okay. Scott, say somebody's making periodic payments on their account to you. How often do you update the creditor about the payments?
Well, the creditor is going to get their portion every month.
So then does the creditor update the amount of the charge off on the credit report, or you don't know?
Well, like I said, my clients generally don't report.
Okay, I missed that part. Sorry.
Yeah. So I'm not reporting, they're generally not reporting. If some defendant debtor wants, the consumer wants, hey, I want something to show the credit reporting agency that this is resolved, I will provide him with a signed letter on the letterhead. I will send them an original note if I have it marked paid. For example, I've inherited auto loan cases. I will send them a notarized blue ink signature letter saying this debt is paid. Please release the lien on the title. I'll send you whatever will help you that you want to send on to. But I'm not going to send it directly to the Secretary of State. I'm not going to send it to the credit reporting agency. I'll send it to you, and you can do whatever you want with it.
Okay. Thank you.
All right. So we have a question on the chat line. What do you do if you intend to communicate with you, be accountable, be realistic, but you're not working, you're not currently working? What do you do about that debt and the fear of you getting a judgment against someone that is not working?
I would ask them to back it up by some documentation, like an unemployment statement or something like that. Or I would want to know why they're not working. I might send them a personal financial statement form to fill out. I might ask them, well, fine, here's a consent judgment, and it says on here, no collection activity for 90 days, or no collection activity for 180 days, because I got to finish the case. But if you can't pay and you're clearly you're in a hardship situation, or you're thinking about bankruptcy, I'm like, okay, I don't mind if you file bankruptcy. I just got to finish off this case, and I got to do my diligence to my client. So you know what? Here's a judgment, and I'm gonna say I can't do anything for 90, 120 days. Go do your bankruptcy. I'll write it into the judgment. No collection activity for X amount of days, or no collection for 90 days, and on afterwards they'll start paying $10 a month, and then after 2 years it'll go to $30 a month, whatever. If it's pre-suit, I might say, okay, well, here's a settlement agreement. Just you make nominal payments, and in that, good faith payments, whatever. It's hard for me just to do nothing, right? I've got to do something for my client. And it also just depends on the debt. If it's a very small debt, then we might just write it off if you backed it up.
What does bankruptcy do when you're pursuing someone for a debt, either pre or during litigation?
Well, if they file a bankruptcy, it puts a stay on the litigation, prevents anybody from going after assets of the debtor or assets of the bankruptcy estate, and stops all litigation. Now, depending on the creditor, if it's an auto loan and it's a nice car and you're not paying for it, they very well can move for relief from stay and take that car, unless you got
what's a relief of stay?
It's an order. I file a motion to the bankruptcy court to get relief from the stay prohibiting legal action, and those are typically granted unless you can show that you've got a plan to reaffirm that particular secured debt, or some other way to wrap it up and pay it eventually.
Do you handle, or have you handled, private or public student loan? Private being just from a bank, public meaning from the Department of Education.
I've not handled public student loan, but I do have ongoing cases for private student loans. Yes.
Do you know any of the rules or ways for someone that has a public loan to avoid paying or to get out of what I consider quite harsh punishments.
Both private and public are technically non-dischargeable in bankruptcy. How, and in particular, public more so. And if they want to get it discharged, they're going to have to file an action for declaratory relief that they are such a hardship candidate that they deserve to have the student loan wiped out.
Are the hardship rules still really hard to qualify for?
I have not practiced in that heavily. I have read some of it, and it's a mixed bag. Particularly in private student loans, they seem to be, the judges are more hostile to having private student loans be non-dischargeable.
Do you have clients that you represent for private student loans, and then suddenly, as what's happening in the billions now, their debt gets waived? Does that mean you can't collect on it?
I've not had any waive because none of these waivers that I have seen apply to private student loans. There have been a few that cases involving schools
DeVry,
for-profit
yeah.
universities that charged a lot and then had a lot of debt tied into it. Those are like a niche area where things are getting wiped out. But most of my student loans are legitimate, state universities, and have nothing to do with that kind of stuff.
Do we have any more questions?
Yeah, I
Mark?
have another one if you don't mind.
Thank you. Go ahead.
Okay, so Scott, so just a little background. I've been settling debt on and off for about 8 years. And do you think there's anything attributing to the fact that when I first started settling debt, a third party like Crown Asset, their settlement options would start at around 40%. Like we would be able to settle for 40% quite easily with Crown Asset Management. And nowadays they're starting at like 75 at the very like lowest point. Do you think that anything attributing to that, like such a leap in what they've been asking for lately, even with the lawsuits back in the day, we were able to settle for much lower than what they're settling for now. I wouldn't think it's inflation because it's still the same percentage of the money. Do you think anything's attributing to that raise in expectations?
Well, I think it is inflation, and I think it's the economy. I mean, we have nearly full employment right now, and their employees are getting paid more. Their costs are higher. So I think that's the factor. I can't, other than that, I wouldn't know. I think.
Speaking of factors, what factors in your assessment or your desire to settle with somebody does the increase in housing prices have right now for you?
Very little. I think the economy in Michigan is really good. I haven't heard that many people. I mean, I hear it a little bit, that that doesn't make me discount the amounts owing. It may make me give them a smaller payment per month. Again, if they back it up with documentation, and I have these personal financial statements, that they truthfully send me stuff, particularly if people have a big debt, 20 to 50,000, I want more documentation before I just, put them on a payment plan that's going to take a decade. Clients really want these things paid off in 4 years, 4 to 5 years. Do we go longer? Absolutely, but I need some supporting documentation, particularly if it's a small debt. I mean, 7,500 or less, I'm not going to string this out for more than 5 years.
Back to Aaron's point, is there anything one generally can do when he's facing a debt buyer, debt collect creditor that won't come down and won't go lower than 80 or 75%? Is there anything else one can do to work that person? And including, hey, can I talk to your supervisor? Hey, can I talk to somebody else? Or, hey, so go ahead and sue me.
offer a bigger down payment or offer a lump sum.
Now,
mean-
doesn't a debt collector, back to my question in a second, when you get a lump sum, and forgive me for sounding cynical, but doesn't the debt collector prefer to have a payment plan? Because the odds are is the person is going to miss a payment. Now you can exercise on the whole amount instead of the settled amount. And so debt buyers or debt collectors want payment plans, and it isn't beneficial to do a lump sum. What are your thoughts?
No, I don't. I think they'd rather have the money and move on. Absolutely.
Okay.
Particularly the commercial clients. Particularly the commercial, the bigger ones, the bigger the debt, I mean, the riskier it is that you're going to get that money over time. So
So they don't care that it could quickly go to judgment and save them all the chasing of litigation because you missed a payment. They would prefer to get up front still.
absolutely.
Okay.
I would prefer to get payments personally for my
All
law
right.
firm, but I don't
I
mind
get the
taking-
sense that you are very hands-on. People aren't just calling somebody that works for you, that you do a lot of the hands-on work.
Yes, one of my clients, you have that rule that, meaningful attorney involvement.
Hmm.
They say, Scott, you have way too much meaningful involvement in these cases.
And why is that?
Because I get down in the weeds and I figure out what's going on and get into their background and look at these things. So it's almost like, like I'm like one of those criminal profilers or something like that, where you're trying to the psychology of what they're doing. And I'm not meaning that in a bad way, but particularly I often have very big dollar cases with bad actors who have transferred assets away and are gambling it away. I got one guy who basically embezzled. He got one of those factoring agreements where he sold his accounts receivable for like 70 grand. He sold 100 for 70, took the 70 and then gambled it at BetMGM. And so he just squandered this whole, and then he took all the money from the business and embezzled that and gambled it away. So now I'm going after his gambling. We're gonna file a non-dischargeability action. The guy makes $25,000 a month as a anesthesiologist and owns a tire shop.
And he's gambling.
And he's gambling. He in fact, I got his records from BetMGM, and he made 14,000 bets in a 2-year period. 14,000 online bets.
How large? What's the average?
$5 to $500.
To get comped?
He won 1.5 million and he lost like 1.6, so he ended up like a negative 250,000.
Wow.
So I tried to do them. It was like a bet like every 1.5 minutes or something like that. But he would do like dozens at a time, right? But if you averaged them out over the course of the year, it was like multiple bets per.
I just see a patient laid out, passed out, and he's got the phone resting on the patient while he's doing his job, BetMGM.
And now he's in bankruptcy. It's a mess. Yeah. I'm gonna sue him for non-dischargeability.
I should have asked you about this earlier. 3 times now you've used the word media to describe what you look at when you're deciding to sue or to settle. What is media?
The underlying contractual documents and then the account history documents.
When do you have the underlying signed agreements? Do you always have that?
95% of the time.
That's extraordinary. I haven't seen it in years. I never see the underlying. It's always a copy, especially if it's Discover or Citibank.
Well, do I have a digital copy of it? Yeah,
Uh-huh.
I don't have paper copies.
Or the
Except-
sign.
Yeah, I have signed. Most of the time I have signed, whether digital or otherwise, but they're copies. The only time I get originals is in those mortgage cases.
They're gonna be in a safe. They're gonna be
Yeah, they're in
locked
some
up
safe, and then they ship them to me, and I have them, and I literally have them in my hand. Like, Your Honor, I have the original note in my hand. How can I not have standing?
And did you win?
I did win.
All right. Well, does anybody have any more questions?
Yeah, I have a question.
Great. Let's keep it going.
Is it me?
Yeah, go ahead.
Yes, sorry, go ahead. Sorry.
Great. Okay, yeah. So I have a judgment against me from 2008, and I wasn't sure how they got a judgment. I previously went to court in 2007, but it seems they filed a judgment against me in 2008. I didn't receive any papers. And now it's 16 years later. So I think I have a motion filed next month, and I wanted to know what's the best way to proceed.
Are you in Michigan?
No, I'm in Maryland. I'm in another state too.
Okay. Well, I
So
would get
the judgment was in Massachusetts, but I'm in Maryland, correct, currently.
And are they domesticating it in Maryland now?
No, it's in Massachusetts.
Okay. And there's a motion for what next month?
It says a motion for a motion hearing.
To do what?
I'm not really
He's
sure.
asking
It says,
Milton. He's asking whether they're turning this one state judgment into the state that you live in's judgment, so they can collect upon it. Is it domesticating it? Look at the top of the paperwork you got.
top of paperwork is a money action. Civil, no, hold on, that's from 2007. I actually have the stuff I got online. I don't have the actual paperwork. I need to go get it.
I would, you really should just get an attorney and have it looked at correctly. Because you got multiple jurisdictions, you got an old case. It may or may not be good. You could call the original court and, hey, can I buy, or can you send me a register of actions so I can see the whole history of the case? And once you see that, you can see what's going on.
Talk to Milton about what the borrowing statute is.
Yeah, it's a private student loan too.
Oh, gets better. You don't know it. Talk to Milton about if it applies the borrowing statute. I think that's where you're going. Where
Well,
what statute of limitation applies to your
Okay.
point.
So it may well be that if the judgment is good in Massachusetts and it's still active judgment, it can be, it should be able to be domesticated or made good in Maryland, and then they can pursue in Maryland. So, but it's only going to be good in Maryland for as long as it's good for in Massachusetts. Once it expires in Massachusetts, it's done.
And I think Massachusetts is 20 years.
So, yeah, so you think it was a 2000, so it still could be good for a while and they could still collect.
Yeah.
So this would be an example of communicate, figure it out, maybe reach out. They found you because they're sending you stuff.
No, they're sending stuff to my
Old
mother's house
address?
my mother's house in Massachusetts.
All right. So is he on notice if they're sending it to his mother's house? Milton, your state ID, what address is on your state ID?
Maryland.
And where is the thing is in Massachusetts?
Yes.
And they're serving your mother in Maryland?
Well, they sent a notice in Boston.
So does he have
Massachusetts.
proper notice generally, Scott? I don't think so.
It's post judgment, so it doesn't matter. I mean, they have a duty to send it to his last known address, but he knows about this judgment. And so it's up to him to update his court address, his address with the court. If he chooses to remain in the background and he only gets stuff intermittently, that's on him. He knows about the judgment.
Forgive me, but why is it on him to update his presence and his current address?
Well, if he wants to get adequate notice of what's going on post judgment, then he should update his address and let them know where he is. He can't hardly complain about not getting notice when he knows there's a case.
No, I just found out probably in May though.
All right. You never knew about this case for all these years?
Never. I went to court in 2007. I wasn't working, so the judge said, basically we can't do anything because he's not working. Come back. So I didn't receive anything. And now in May, I get something from my mother's house. My mother called me.
Well, you did know about the judgment because you went to court.
He knew
No,
about the case, not the judgment.
Well, the court would not have cared about his working or not working. That would be irrelevant to a prejudgment issue. So that they cared about him not working, that means he probably appeared for a creditor's exam. And the judge said, well, he's not working, so there's nothing to collect here. You were probably already in a post-judgment stage when you appeared at that time.
You think so?
There was no reason for the court to care about whether you're working or not working unless it was post-judgment.
Hmm.
It's the same case number, right?
Yes,
it
the same case number. Yeah.
Then you knew about the case. I would reach out and I would reach out to the court and get the court record, the complete court record, to see what's been going on all these years.
Okay, so I have like the summary. So it says judgment entered on 10/15/2008.
Okay,
Was that the judgment though?
sounds like it.
I didn't know about this. I must have went to court in 2007, so I didn't know about the
Your
judgment.
appearance, your hearing would be on that record.
Yeah.
When did you leave Massachusetts?
6 years ago.
Ah, so you're on. You're not. When the older the judgment is, the less chance you have of getting out of it. In fact, the Michigan rule is it's got to be extraordinary. And I suspect Maryland and Massachusetts also have an extraordinary rule as far as getting out of a long-term judgment. I get where you're coming from. I disagree with Scott, and I bet you Scott's right, and I'm not. But bad notice means I'm not on the hook. But to Scott's point again is you kind of are, and to protect your backside, you should investigate whether you should step up to this. An attorney in your, I don't know, should he get a Maryland attorney or a Massachusetts attorney?
Probably Massachusetts. I mean, you've gone all these years. You only got about 4 years left in this judgment. So chances are they're probably not going to collect a whole lot.
Yeah. And that's a point. That's a good point. So for example, collectors, they can't collect from you, but they'll go after your state taxes. So to Scott's point, that they can only do that for 4 years. Then you're done. So Scott's not telling you what to do, but you really don't have much fear of much money being taken. Is that what you're trying to say, Scott?
It'd be a lot more work. Yeah. Hopefully they're not watching this show.
How big is the judgment?
Well, the original debt was 7,000, which went up to 12,000 once the law firm went to court. But now this thing ballooned, so it could be, I don't know, 26,000. I'm not even sure.
What's the name of the plaintiff, the actual company that's suing you?
Mountain Peaks Financial Services.
Is that the original creditor, or is that a company that bought the debt?
That's the company that bought the debt.
Aha. So they paid pennies on the dollar for it. I don't know if they're going to chase you that hard. That's just my opinion. I think you're in better shape than you realize. You know, a lawyer letter or something legal in the mail always shakes you. But the reality of from 30,000 feet is it's a debt that's going to be done in 4 years. The other thought that Scott didn't mention, but he really kind of has, is talk to your attorney, get the best information. And I'd say, maybe I'm wrong about this, Scott. I know you're going to say yes to this, but Milton should reach out and see if he can make a deal if there's a fear that it's sitting over his head. Maybe it'll take 1,000 just to go away. If, as Scott says, you can present them with a hardship, like, I'm getting this amount of income. This is my debts. This is my revenue. You may be able to get, they want something. And then you agree, take it off my credit, dismiss with prejudice once I make payment. And you get out of there with $1,000. What do you think, Scott?
Have an attorney do that and not disclose where you are.
Perfect.
Yeah, so I have a virtual hearing, so I'm kind of wondering if they know where I'm at.
Well,
I'm
how
having
do
a
you know you have a
virtual hearing.
virtual hearing?
The stuff was sent to my mother's address.
Okay, so you got to get an attorney right away. Why? Because you don't want to show up at the virtual hearing. You want to keep, if you will, this fiction going of what is this? What's going on? You don't want involvement. The judge will latch on to that. I think he needs an attorney to show up for that hearing. What do you think, Scott?
Yeah, I think I would agree.
But talk to the attorney before you do anything, any virtual hearing. It's worth it. A couple $100, talk with an attorney, definitely worth it.
Okay, and then as far as my paperwork, how do I get that?
Call the court and ask them to email you a copy.
They can do that?
Possibly, they might charge you a fee and they might say, send us a check for da 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 and a return envelope and we'll mail you a copy.
And you got some good attorneys in Maryland, by the way, good consumer protection attorneys in Maryland.
It might even be available online if you search for the court online and try to find. It might have many Michigan courts are available online.
And we're not giving you legal advice, Milton. We're just problem solvers. All right.
Okay, so I should contact a Massachusetts lawyer or Maryland?
I'd say Massachusetts.
After you get the court record.
And a local one, local to the court, so you don't get hometowned. You know what I mean?
What's the term hometown?
So
you want
you got
someone
a case,
who knows the local court.
Yeah, so if you got a case 200 miles away from where you live and the local attorney's on the other side and you show up from, let's say in my case, it happens to me all the time, Detroit, they're going to have like a prejudice against me because I'm out of town. So you want a local attorney so you don't get hometowned.
Okay.
An attorney from the hometown.
Okay. I understand. All right.
All right.
Yeah,
Someone's asking, do we know any good consumer lawyers in New Jersey? Yes. First off, Google, but yeah, New Jersey's got some really good. I used to do a lot of consumer conferences. I don't do as many. I'm just too darn busy, but I always met a lot of good attorneys. It's also, if you will, a very liberal area as far as the courts are concerned. So consumers do quite well there. Philadelphia, New Jersey, really good attorneys there. Scott, did you ever do evictions?
A few.
What's the difference between a summary judgment for possession and a summary judgment for damages? Because I was in court a couple of days ago and a person got a judgment for just eviction, but not the damages. And he said he's going to do that later. How do you do the bifurcate?
It's just depends on to what degree how desperate the landlord is to get the possession back. So you can get summary judgment for possession without personal service, just by posting on the door.
Wow.
Okay. But then if you're going to go that route, you're foregoing any money judgment. If you want possession and a money judgment, you actually have to get personal service or the alternate service order. So if you don't care about the money, you don't think you're going to collect it, then a lot of them will just say, just get rid of them.
Can you go back a month or two later and then go for the money judgment?
You could, yes.
Okay, good.
But it's got to be a lot. It's usually not worthwhile.
All right. Do we have any more questions? Scott's
I
been
have one more.
Go ahead. Oh, it's Miss Kidd again.
It's me. And it's really directed to you, Mr. Parker. It is only because I'm unsure. So I got a complaint and I was trying to get a request for discovery. The only thing is the way that the complaint was written, it was written as a breach of agreement or breach of contract or breach of account, account stated unjust
enrichment. Yep.
Yeah. And I don't know how to write a request for discovery on that specifically, because the one that I had prior had entities that I could write in, but there's none for this one. So I'm not sure how to do that one.
Are you familiar with the game? I think it's called Jenga.
Yeah.
What is the Jenga game?
Where the boxes where you take the puzzle pieces out.
Right.
Uh-huh.
Eventually one piece.
Yes.
So pick your poison. I would do an adequate defense of obviously the answer counter defendant, but who, by the way, who's the plaintiff against you?
That's the credit corp.
Oh, that you're in great shape. So just go after them on the proof or the assignments, or Scott says the media, and you'll see that it's wanting. It may be a big bill of sale, but it won't be specific to you. Don't worry about having to seek discovery on unjust enrichment. That's a throwaway. Most national wide, most collection lawsuits are account stated, breach of contract, and unjust enrichment. Sometimes not breach of contracts, depends.
Mm-hmm.
But that's a great credit core you can kick out of there quite easily. So my point in discovery, which by the way, don't worry about that right now. You're in an early stage. That discovery won't be awarded for a month or two. Then go do your work. If you're on a member of my site, all the discovery you are, okay, all the discovery you need, you just change absolute resolutions and put in credit core, have it apply to what you're seeking. Okay. Most importantly, and this is more of an attorney advice, have a hill that you can die upon. What do I mean? Don't ask them 50 requests to admit, 50. Just keep it below 10, specific to prove to me my debt was assigned to you. Just that discovery alone will probably settle the case if you get that far. Okay. And having a hill to die upon means have it be important that you're going to, if you will, waste the judge's time. You're going to need to do a motion compel. Have that in your head. So how would you want the judge to receive your discovery requests? If you have just a few to the point, every judge would love you for that. So they don't have to go through everything. He'll say, or she'll say, oh, this is a simple issue, single issue. Has the plaintiff met their burden of proof? Unlikely. So don't worry yourself about proving or disproving unjust enrichment. Just go for that small Jenga. What trips this whole case up is standing. And if they don't own the debt, they don't have standing. Their burden of proof is to provide you with the paperwork, which 99 times out of 98, they can't do that. That's my experience. I hope I haven't spoken too much, but you're in great shape.
No, you have not. And I wanted to thank you so much. I did have to go get a lawyer because I got a little nervous. I was unsure of things. And I did give him all my paperwork. And he did say, well, I don't know why you need me because you have everything that you need right here.
Yes.
Thank you. But I was a little nervous, and that was the reason why I did. But I did all of the work. So he was just like, you did all the work here. You know, everything looks fine. He said, what do you need me for? So
all right. Education eliminates anxiety. You're doing great. You're doing better. You're so money, you don't even know how money you are. You're doing great. All right. We're going to talk to A. Santana now. Thank you.
I posted my question, but so I am, Mr. Parker, we spoke last week. I'm in the midst of a de novo case, and I was recently told by the attorney that they want to push it back because of their witness regarding this. Now,
okay, so I'm going to cut you off because I'm rude, but I heard something I have to address immediately. I want you to ask yourself, what's the benefit to you?
If they push it back?
Yeah, if they can't get a witness, that's fantastic. Don't help them.
Okay.
Her attorney can't get a witness, or the other attorney or the opposing counsel can't get a witness?
I don't have a witness. I'm representing myself. It's the trust attorney that.
Yeah, okay. They can't prove anything. So you don't let them move that. There's no benefit. If they said move it and we'll give you XYZ, Fine, but what's the benefit for you? You're not there to help them. They're
Well,
not
they
there
already,
to
they
help
lied
you.
in the letter. I received the letter from the court. And it's their letter to the court was asking to move the date because their witness was not available on the date. And they said they tried to reach me, but I did not respond, which is not true. They never tried to reach me. So they proposed a couple of other dates.
Yeah, so they might get their way, but it's treat it like politics. Don't let anything go unresponded to, right? Otherwise, it sits out there as truth.
Right.
So write a letter. Oh, I am aware of what happened. I did not know this is going on, whatever your position is. This case is dragged on for 2 years now. I don't want to add any more time. I want this out of the court's hair. I want this resolved. And my thoughts, by the way, Your Honor, is if they don't have the witness by this time, please, right? So you may not win that, but don't let stuff go. And if I recall you now, if I'm thinking, are you the lady from New York, New Jersey in education?
New Jersey, correct. Yes.
Okay. So there's been a bunch of stuff there that they haven't done. I would throw in a couple of sentences, keep it polite and nice. It's interesting that the other side says this because so far, this happened, I didn't get noticed. This happened, I didn't get noticed. Make your case for what you and I were talking about previously about the due process that puts you in this de novo, as you call it, status.
Right.
Is that clear?
Yes.
Never miss a chance to avoid someone telling you how to litigate your case. That's number one. And number two, don't let anything go unanswered.
Okay.
Because the
And
judge will just take it as gospel.
Okay. My other question was, I know you and I talked briefly about the TILA, but we were going really fast with a lot of things.
TILA?
Yes,
That's a Scott question. Go ahead, ask Scott.
So Scott, this is a 2+ year case. And during discovery, as we went back and forth and I asked for proof of the debt, the first time they sent it to me, the TILA summary sheet had X number, X interest rate. And I looked at the very, very top and it had one date. Then when I further asked for further information, they attached again another TILA summary sheet. The date on top had changed. The interest rate had changed by 1/10, but it was nevertheless different. And the amount as a result of the interest being different, everything else changed. Additionally, they attached 4 or 5 months of monthly statements. Those monthly statements are different from both TILA summary sheets in their interest rate and in the monthly amount due.
Scott,
Now,
is something rotten in Denmark?
Not necessarily. What was the loan for?
it was a personal loan.
Was it like an auto loan or a
Lending club or web
a
bank?
No, it was a personal loan.
Did it have a variable rate of interest?
It did not. It's a fixed rate interest.
Well, it's not unusual that you might have a preliminary TILA and a final TILA, because there might have been like a period where you're applying for the loan. This is particularly true like in mortgage lending where it takes a while to get approved. So you might have a preliminary and then they might have a final.
This was online and it was a personal loan. It wasn't a mortgage. So you either immediately you get approved or you don't.
Okay. I don't believe TILA is a defense. A TILA violation is a defense to a money owing debt. And a RESPA violation is not a defense either. It's just a separate counterclaim that you might own. You borrow the money. The fact that maybe you've got disparate TILA statements now in their records doesn't mean that you didn't get a TILA statement that was accurate at the time. And I don't believe that any of those, I don't believe an FDCPA violation is a defense to a debt owing either. None of these things are defenses. They're all just counterclaims.
What about the monthly
What does that mean?
statements?
What's that mean?
It means that you legitimately owe this debt they may also have made a mistake and done their paperwork incorrectly. They don't negate they don't negate the debt. They are not defenses. They are claims that, because there may not be even contemporary in time, right? You got this money and you made payments and then you defaulted probably, and now you owe this money. The TILA violation was even before you even took on the debt, right? It was something, it was documentation provided to you regarding your loan before you even signed off. So I don't believe it's all that significant. The only thing that's significant is what is the interest rate.
And doesn't the person that takes the debt, claims to own it, stand in the shoes of the original creditor when they get assigned the debt?
Is this debt even assigned to anybody, or is it still the original creditor?
So the way they present it to me is, it is a tremendous long name. So the original creditor is SoFi. The
Okay.
way their defendant is, well, I'm the defendant, the plaintiff is presenting themselves, it is SoFi as attorney in fact for Wilmington Trust, National Bank as trustee, program C 2019-3.
Okay. It
That's
sounds like SoFi
securitized.
is still involved.
I'm sorry, can you say that again?
It sounds like SoFi as the original creditor is still involved. It sounds messy, but I don't believe the TILA. I guess you should ask them what interest rate do they think applies.
Well, how about the monthly statements? You don't think that that's something else that's alarming? Because on the TILA sheet, on the TILA, both TILA summary sheets, it says an individual would get a 0.25% off if they allow it to be a direct debit from the account monthly. When you do the math of the 0.25% off from the interest rate that's on TILA, it doesn't add up. It adds up to, it doesn't add, the interest rate that's on the monthly statements are dramatically different. It is more than 1.5% of an interest rate difference on the monthly summary sheets that were submitted as evidence.
And I think it's evidence that they don't own the debt.
It seems like those papers were fabricated, is my assumption, but
what do your statements say? Did you save your statements?
I do not. This is over 2.5 years ago.
Shoot. Do you have any statements that you can compare?
That's
a good
not.
point. Darn it.
I only have what submitted, and nothing that they submitted in terms of here's proof of the debt is consistent.
All right, we'll play that up. Consistency is important in when you're claiming you own something and you have standing. I think you're onto something there. There's too many, when it comes to money, there's no accidents. There's no coincidences. And it sounds like the problems and incorrect information favors them. Yes.
Well, I don't know if it favors them or not. I just don't understand, why would the monthly statement, if the interest rate is 10, why is your monthly statement interest rate showing it's 11.5 or 12? Wow. It's a dramatic, the monthly statement, and it says your monthly statement on TILA says, as an example, it's 15.5 and you're going to pay, X amount of dollars. The monthly,
I think that goes to ownership.
Let me say this. These things don't happen for no reason. So either A, you're potentially incorrect that it's not a variable rate of interest. B, there's a default rate of interest that kicked in after at some point in time that there was a default, and therefore your rate changed. Or there's some other issue in the original note or loan document that allows the interest rate to change. And I also want to say this, and Brian may disagree with me, is that there's a constant tendency upon consumers to elevate form over substance. Okay. Whereas you're getting into the minutia of, well, this statement's not right, or this doesn't look right to me. Well, all the while this money was in fact borrowed and was in fact defaulted on.
All right. So that's where Scott's coming from. But he has a really good point. He actually is helping you. He's giving you, and this is you may want to try this. Let's try to say, all right, I think they did the right thing. Where's the supporting paperwork that allows them to charge a default interest or to create the interest? You've probably got from then or on your own a copy of the loan agreement. And does it say if you default, interest rates increase, blah, blah, blah. So
that's
try to justify what they're up to, Miss
Okay.
Santana.
These documents are incredibly boring sometimes.
right.
I frankly got to read them 4 times to understand them.
Okay.
So read and reread.
But
and
his
get
point
the whole
is
thing.
attack what's supporting them. See if they're right. And if he's giving you great advice, because
Right. Well, I just want to say one more thing. I did reread and reread because I couldn't believe there was such disparity. The interest rate actually went down, gentlemen. It didn't increase because it defaulted. And it says a fixed rate. I read it. I had other people read it. I said, am I missing something? It's a fixed rate at a higher percentage, but the monthly statements dropped more than 1.6% difference.
all right. So
the error is in your favor. So there's really no much to argue about.
All right. So I think there is. We're going to move on to our next question. Okay, Miss Santana?
Okay, thank you.
Thank you. Very good. Great talking to you. Aaron, I think it's you. Aaron?
I'm sorry, that should have been lowered. My fault.
Oh, you're good?
Yeah, I'm good. Thank you.
All right. Woo. That was some good questions. I hope it's helpful. Does anybody else have any more questions?
I had one more question.
Go for it.
So how do you find a good attorney in Massachusetts? How would I?
Oh, you'd
for an attorney?
Google local to, if it's your mom's house, the court is in, where the court is. You obviously know where it is, the town. Google, and okay, here's the search term. I guess I'd go Massachusetts, whatever the hometown is, FDCPA attorney. FDCPA attorney. Does that make sense?
Yeah, that makes sense.
Because that's what they do all day long. So, and you may have an FDCPA violation. I'm not saying you do, but he or she's going to take a look at that. But that's what they do. So I hope that helps.
Thank you.
Good luck. Thank you, Milton. Scott, any last words? What you'd like people to know about how they can handle their debts if they come to you or anybody else?
Don't procrastinate. Reach out. Be civil. Don't raise your voice. And just have a conversation.
Milton, somebody has pointed out nicely, the Bar Association has lawyer referral services in Boston. So
Okay,
that's
thank
a organization set up to do all the work for you. Just called, they're promoting, and that's the public policy of every bar, is to make sure people get represented. So they'd be more than happy to find you the attorney. And if they're referring the attorney, that means they trust the attorney, then that's a little bit more trust for you. Does that make sense, Milton?
Yes, it makes sense. Thank you.
There you go. So do the lawyer referral service in Boston. Excellent. Oh, this is very good. Scott, you're great. This was very nice. I'd love to do maybe a podcast with you once a month or something.
Okay.
And we kind of butted heads in a good way. We saw things differently. And that was the number one point of this. There's always two sides to things. And here's how the debt collector thinks about things, not just what Parker thinks. Parker doesn't see ownership of anything, but that maybe Parker's got his head in the clouds. But you presented a very good other side of the fence approach. And I thank you for your
You're
time.
welcome. Been fun.
And everybody should know I rarely see Scott in the suit. So that's how much he respects you guys. So
I'm going to sign off then, I think.
See you later. Oh, look at everybody. Look in the back. He's got a cat stand there. Ooh, how many cats do you have?
3.
Oh, all right. We'll leave now. We'll talk to you guys later. Thank you very much for showing up and asking great questions. See you, Scott.
Have a good weekend.
Be good. You too. Bye bye now. Stay out of the